Stephen, auditors, like big accounting firms, have been around a long time, and they've been subject to litigation for decades and decades. I'm just curious. I'm just curious. What do you think? How have you been able to be so successful? What did you figure out in terms of like, I'm going to pursue these firms for their negligence, or in some cases, gross negligence. What have you been able to figure out that's allowed you to have so much success, but not just for yourself, of course, but on behalf of the victims of the fraud?
Well, when we first did this, and I would say the first case against BDO that we talked about before, when I was at Sullivan and Cromwell, we knew that in lawsuits against accounting firms, the accounting firms were winning, something like 95% of the suits are settling for just a small amount of money. And it was because, in part, the accounting firms were convincing people that it wasn't their job to find the fraud. And when we started doing mock trials before our big trial, we were getting beat up pretty bad. So we were losing too. And one day we'd lost pretty bad in the mock trial. And I was sitting with Emily and Mark and our local guy who's been in a lot of cases with us, Gonzalo Dorda. And the jury consultant we had at the time was saying, you can't ask for punitive damages, and you guys should settle this case. You have no chance of winning. And we kicked him out, and Emily was like, are we going to settle? And I was like, no, because we know we're right. We know what they did was wrong. We're just not figuring out how to do it. And Emily actually is the one who said, well, it's their job to find the fraud. And that's what the rules say. And we then took what was supposedly the bad facts and made those facts the reason we won, because it was their job under the rules. And we thought we could convince jurors and judges that that's what the rules say. And the rules really haven't changed since 2007. And the Rule Act says that an auditor's job is to provide reasonable assurance that the financial statements are not misstated due to error or fraud. And so that's what we did. We changed our pitch. We sold out, and we told the jury, if you think we didn't prove it's their job to detect fraud, rule for them. And no one said those kind of things back then in any case to juries. If I don't prove my case to you, rule for them. And that's what I stood up and said. And I said, if you don't, and then the defendants, the big thing they were hurting us with in the mocks was that it was too complicated for the jurors to understand. It was all about accounting, and that had been very successful to them. So we told the jurors, if we can't explain it to you, when you get to the end of this and you feel like you don't understand what the rules are or how to read a financial statement, you think you don't understand it, rule for them. It's my job to explain it to you. Huh. So those two things, I think, made a real difference for us. And then the final thing that we discovered was, I'll just say it, telling the truth actually is a very powerful tool. And in general, we find that the big defense firms and they put their witnesses on the stand and they don't tell the truth. And we prove they're lying, and it really helps us, and we make sure our witnesses tell the truth. And it sounds hokey, but I've found out over the years that judges kind of just think that lawyers lie and witnesses lie, but that's not what jurors think. Jurors think you should get on the stand, you take an oath, you're supposed to tell the truth.
Right.
So they put these witnesses to lie about what they did, and we prove that they're lying, and I think that's very powerful for us. So I think those are the three things we sort of figured out, and it's been very successful.